Good afternoon. I'm Sarah Gomes with Job Service Kalispell. Thank you for joining us this April to attend Blueprint for Business Success's fourth seminar in our 2021 Spring Series. Please take a moment to help us identify the businesses benefiting from today's seminar by entering your name, title, business you represent, and your city in the chat box. Attendees are muted, but we encourage you to use the chat box for asking questions, which will be answered at the end of the presentation. Of course, we ask that you please be polite and respectful to all attendees and the presenter. The 2-minute anonymous survey when you leave the seminar helps us improve this program and provide meaningful topics and content. Today, we have the privilege of hearing from Logan Jackson as he presents on the topic of wage and hour laws and independent contractor exemptions in Montana. Logan has worked for the Montana Department of Labor and Industry since 2016, serving in a variety of capacities, including licensing permit technician and investigator. In his current role as compliance education specialist, he is working to promote education and provide the best possible service to all Montanans. In addition to his career with the Department of Labor and Industry, he has 16 years of experience in the private sector, focusing on leadership, team building, and change management. Logan has a Bachelor of Science in Marketing Management and a Master of Science in Management and Leadership, and he's currently pursuing an MBA. Ladies and gentlemen, here is Logan Jackson.
Good afternoon, everybody, and I appreciate everybody being able to attend. The number one takeaway I would say from today is any questions arise from what we discuss or anything in the future, be sure to go ahead and reach out to our office. We are a resource for you guys to utilize. All right, so we will jump right in here. So as indicated prior, I'm with the Compliance and Investigation Bureau of the Employment Relation Division, the Montana Department of Labor and Industry. What we oversee is the employment relationship, independent contractor status, wage and wage protection, minimum wage and overtime laws, work comp, compliance, child labor laws, and prevailing wage. We're going to try to cover a lot of ground today, and I'll do my darndest to get through as expeditiously as possible so we can answer any questions. But again, we're not going to be able to touch on everything in depth, so please feel free to reach out to our office. We'll start with the employment relationship, as that's often an area of confusion. So between an independent contractor and an employee, how one is paid or how they file their taxes is not definitive of whether they are truly an employee or an independent contractor. The situation has to get unpacked a little bit. The independent contractor statute is addressed through the work comp statute portion of the MCA, and it indicates a person who regularly or customarily performs services at a location other than the person's own fixed business location shall apply to the department for an independent contractor exemption certificate unless the person has elected to be bound personally and individually by provisions of comp plan 1, 2, or 3. So basically what that is saying is if an individual is in business for themselves, they can either cover themselves under work comp. So plan 1, 2, or 3 are versions of workers' comp plans. Plan 1 is a privately insured. Generally, those are incredibly large organizations. Plan 2 is going to be, Plan 2 is privately insured. Plan 1 is self-insured, rather large organizations. Plan 2 is privately insured. So the same folks you may go to for general commercial liability, other types of insurance, et cetera. And Plan 3 is the guaranteed insurer for the state or Montana State Fund. If they choose not to do that, an individual can apply for an independent contractor exemption certificate. The fee is $125. There's a modicum of documentation that has to be provided, but it's literally a waiver for work comp. A fixed business location, that's a fairly important portion of that as well, because If an individual, let's say, is working out of a home office or another premises that they own, and they're working out of that fixed location, they don't necessarily need either to be compliant. Certainly, a lot of folks still would opt to get work comp depending upon the nature of the work, or an independent exemption certificate if they're going on site. An example I can give is years ago, I knew of a gentleman who he built custom cabinets in a pole barn on his property. Initially, he never left the property. Had a home builder in the area request that he not only would build them, but would install them. So he contacted our office, as well as he did his own digging through his insurance company and Montana State Fund. And I believe he determined to go through whomever he had his general commercial liability for, so he could be on the job site functioning in that capacity. So generally speaking, there are a few statutory exemptions. For instance, corporate officers, managed LLCs, individuals who own 20% or more of them outside of the construction industry are two of the more common ones that don't need an ICEC. But generally speaking, if work's being performed away from a fixed business location and an individual doesn't have work comp, then they're going to likely need that waiver, that individual exemption certificate. So as the relationship is reviewed, whether or not an individual is an independent contractor or an employee, the first step in the primary is the common law definition being referred to as the AB test. So must be free from control and direction and must have their own independently established trade, business, or occupation. And that should be listed on an ICEC. Both of these must be true. It's not an and or situation. So when we get into the matters of control, there's four factors there. The direct evidence or control or direction or the right to control the worker, furnishing of substantial equipment, the method of payment, and the right to fire without liability. So the direct evidence of control or direction or the right to control the worker, that's, for instance, if somebody's told when to show up, how to perform their work, when to take a break, when to take lunch, that's more indicative of an employee than it is an independent contractor. One would expect, if they're hiring an independent contractor, that they likely know how to do the job you're hiring them to do. They likely don't need that sort of direction. Likewise, generally they're working on more of an open time schedule that's addressed in the initial working agreement or contract. That's going to address the timeline for the build. Furnishing of substantial equipment. This is one that has gotten some folks into some situations a little bit, because it's, again, an independent contractor should have the tools to do their job, one would expect. Likewise, materials should be furnished by the independent contractor, generally speaking, rather than the hiring agent. If tools and materials are supplied, that's more indicative of a employee-employer relationship rather than a hiring agent, independent contractor. On a method of payment. So the Work Comp Court, as well as the Supreme Court of Montana, have both in different rulings indicated that hourly pay is indicative, though not definitive, of an employee. Likewise, pay on a project is indicative, though not definitive, of an independent contractor. So neither one in and of itself, and none of these in and of themselves are definitive. They get reviewed in totality. The right to fire without liability. So in an employment arrangement, the liability acts in the wrongful discharge from employment act, where generally speaking, the contractor and the hiring agent, in the contract, it should address what happens if the relationship is severed prior to completion of the project. Likewise, it's not uncommon for there to be a bonus or a type of financial incentive that would get addressed, that if the work gets completed prior to the anticipated date. So the idea of the balance or the scale there on the left is that when an investigator or an auditor or an inspector or somebody's reviewing the relationship, every fact, every bit of evidence sits on one side of that or the other. It's either viewed as employee-like or independent contractor-like. And then when it's viewed in totality, whichever has that higher percentage, so it could be theoretically 51-49, and whichever is 51, that is going to be the ruling. So everything is reviewed independently there. This is what an approved independent contractor exemption certificate looks like. It's going to give the name, the date issued, the date through, a certificate number. I guess one important point is this is not a license. There's no test involved. There certainly are licensing through the state. However, that's through the Business Standards Division. And generally it's occupational based licensing. So electricians, plumbers, et cetera. But it's going to provide the occupation which that individual is waiving their rights to work comp for. As an aside, if somebody is hiring an independent contractor, I would always advise them to either get on our website and verify that it is currently active and in good standing, or to give our office a call, and we'll happily look that up for you as well. On to minimum wage. So Montana has a minimum wage of $8.75 per hour. This is subject to annual cost of living adjustment. As an aside, I guess in the time that I've looked at it, I've seen it go up every year. And one shouldn't be confused with the idea of what the minimum wage is versus market value. This is an area that comes up often in wage law. So what the law is indicating is what the bare minimum is. It doesn't indicate that what you can actually hire somebody for either the caliber of employee you wish to have or the particular occupation. That's all going to be established through the market value. Now, minimum wage cannot be offset by a tip credit, can't be offset by a meal credit, it can't be offset by a training wage. So tips, they're the property of the tipped employee. Meal credits, there are other states that allow there to be to have the employer provide a meal, and that can offset minimum wage. That is not permissible here. Training wage, this one gets confused a little bit. So for instance, oftentimes people will have a 6-month probationary period. After that review, the individual may or may not receive a raise if they are retained for employment. So yes, somebody could start at $8.75 theoretically. After that 6-month period, the employer decides they've done a good job and they want to take them up to $10 an hour. Perfectly permissible. Minimum wage is being met. The issue is there are some other states that may offer a particular training wage that is lower than that state's minimum wage, but potentially higher than the federal minimum wage. And that's not permissible in Montana. So jurisdiction in the Fair Labor Standards Act. This gets important as we unpack a few issues coming up here, but generally there's two sort of avenues that one might be covered under. And the vast majority of people working in the state of Montana are covered under the Fair Labor Standards Act. So enterprise coverage is, if the enterprise or if the business has sales of at least $500,000 annually. Hospitals, nursing facilities, schools, preschools, government agencies, all covered under the FLSA. Individual coverage, this generally speaking, is tied to those engaged in interstate commerce. So interstate commerce can be as simple as communicating via phone or email regularly with those across state lines, shipping or receiving items across state lines. In the state of Montana, processing credit cards. There's not a credit card processing facility, I don't believe, currently in the state boundary. Therefore, all of those charges are actually getting processed off-site. So, so even if the business is under $500,000 a year and that employee scans credit cards or check cards to take payment, or receives out-of-state checks or sends emails or goods in between states, they're likely engaged in interstate commerce and therefore covered under the FLSA. What we end up looking at with wage law is the higher standard principle. So if two standards exist, let's say one being federal and one being state, the higher standard is going to take precedence, right? So for instance, that last slide showed minimum wage. The federal minimum wage is currently $7.25 an hour. It would be very difficult. There are a few examples in which it could happen, but for a Montana employer to pay $7.25 an hour. I would always caution if a business either believes their employees aren't going to fall into the FLSA or believes they don't need to meet the state minimum wage to reach out to our office and discuss the intricacies and nuance of your situation prior to taking those actions. It's way easier to have the discussions on the front end than it is to run into issues on the back end. So overtime, depending upon a company's pay period, will depend often on any potential confusion with overtime. So overtime is based on hours truly worked, actually worked over 40 in a work week for non-exempt employees. Holiday pay, sick, vacation, PTO, they're not hours actually worked. Therefore, they're not applicable to that overtime requirement. So theoretically, let's say a employer offered their employees a vacation on Monday and they paid them 8 hours of vacation wages, and the individual was scheduled then Tuesday through Thursday for 10 hours a day. That individual wouldn't be required to be paid 8 hours overtime. They'd have 40 hours of regular time and 8 hours of PTO, or in this case, vacation. As an aside, Montana, or for private sector employees, does not allow comp time. So that is addressed through the FLSA for certain public sector employees, but it is not through the private sector. So establishing a work week, the way that statute addresses this is that a work week is a 7-day repeating period. Okay, if it's not declared by the employer, it's going to be assumed that it is Sunday through Saturday. In the description on your screen, these red circles on the 1st and 15th are indicating pay periods. Okay, so this particular one is a bi-monthly pay period. You can see that the confusion would arise as you have, let's say from the 12th to the 14th here, you have time being worked that is in one pay period, but in another work week. So that's where that 40-hour idea always has to come to play. Generally, people put too much thought into it. The idea is that in a 7-day repeating period, if there's more than 40 hours being worked, overtime is due for that. So a work week could be, a pay period could be weekly, bi-weekly, semi-monthly in this case. And that's perfectly all permissible. They just have different areas of complexity or different levels of complexity that a bookkeeper or business owner just needs to be aware of. And I would strongly encourage, parties to communicate. So if you're onboarding somebody and you have something that's not a weekly or a bi-weekly pay period, it certainly wouldn't be discouraged to address at the beginning an explanation of pay period versus work week, so people can really have an expectation as to when overtime is being earned. I guess as an aside, from my time as an investigator and now doing education and outreach, I think that if both parties avoided ambiguity, if there was adequate documentation and there were conversations, on the front end, open conversations on the front end, I think that would likely cut wage related issues, nearly in half, if not more. So determining a regular rate of pay, individual could get paid a salary, even if they are a non-exempt employee. And let's say theoretically they were on a $350 a week salary. the way we would determine their hourly wage is we would divide 350 by 40 and get 875. Likewise, it shows with biweekly, semi-monthly, monthly, etc. Essentially, and we will get to this further in a moment, but everything can be extrapolated to an hourly rate of pay. It's just a matter of documenting what hours were truly worked and what wages were truly earned, and then working from there. So weighted average overtime, this is another area that I think at times folks just put a little more, I don't want to say more thought, but they sort of get confused in the minutia of it. So in this example, let's say that an individual was working at a server at a restaurant primarily, but then they also worked as a cook. So if they worked 36 hours as a server at $8.75 an hour because they received tips, they made $315 for those 36 hours worked. Let's say they then additionally for that work week worked 10 hours in the kitchen at $9.50 an hour. So you'd take the total hours worked, divide the total dollar value there, and you're going to get $8.91 an hour. So obviously overtime needs to be paid at 1.5 times the regular rate of pay. So that's how that would apply. Conversely, an employer can certainly choose to pay at the higher rate, though of the years doing this, I've only seen that happen once. And that particular example was in the construction industry, and the individual received varying rates of pay based on the exact jobs, the exact duties they were performing during that work week. And one of the pay periods that I reviewed, I want to say they had 12 or 15 various jobs that they were performing for that company, all within 25 or 50 cents an hour of one another. So they figured out pretty quickly it simply wasn't worth their bookkeeper's time to figure out what the weighted average was going to be every week. It was simply more cost effective just to pay at the higher rate. So exempt employees, there's exemptions both addressed through the FLSA and or the Montana codes annotated. These exemptions can be from minimum wage and or overtime. So you'll have agricultural exemptions, you'll have educational exemptions, you'll have a executive, administrative, professional. The big takeaways here is there's a salaries and a duties test primarily. So let's address one thing. 2020 was obviously a little bit of a unique year in a multitude of ways, but one of the things that happened that sort of flew under the radar was the feds through the USDOL raised the salary threshold for the first time in decades. So it had been, I believe, $444 a week that an exempt employee had to earn. That went up to $684 a week. Then there are duties tests for each of these. So for an executive, for instance, they have to oversee the totality or a subsection of the enterprise. They have to have the right to hire, fire, give promotions, demotions, a weighted say in raises, et cetera, and oversee at least 2 or more full-time employees. That could be for part-time employees, that could be 2 full-time employees, et cetera. One tie with all of these exemptions is that they are reviewed via work week. So an example I'm aware of was a small fast food establishment that had a manager, an assistant manager, and then 2 employees. Well, the manager was then an executive exempt employee. They were paid, I believe it was $700 a week salary. Well, they had a little bit of a mutiny there, and the 2 hourly employees walked off. Well, then it left the manager and the assistant manager. Clearly, that manager then is not overseeing 2 or more full-time employees. So the hours he worked during that particular period of time until they brought on new team members, he had to be compensated overtime for his hours worked. Those are reviewed on a weekly work week by work week basis. Administrative, the best description I heard of this was from someone with the USDOL, their office out of Salt Lake. She indicated that it's somebody who needs to write the policy as well as implement the policy. So for instance, you'll see a head of HR, right, which will write policies as well as administer them for a firm. That's a good example. Professional, they're generally tied to advanced degrees or very specific degrees. So you'll get engineer, architects, etc. Also artist rather in a recognized artistic endeavor or trade or a matter of express creativity can also fall under there. Computer employees. Biggest thing with this is it's not the sort of tech savvy regular worker who goes and helps install a monitor for somebody, right? It's going to be a cybersecurity analyst, a programmer, a data analyst, somebody of that sort that's going to have more in-depth knowledge and the predominance of their work is being done specifically there. And there's also a separate hourly rate of pay. I want to say off the top of my head, it's $26.84, but it's been a bit since I looked at that. That can make up their salary as well. And then an outside salesman. The biggest thing here is that the predominance of their work has to be outside. They have to be a road warrior. They can't be in the office cold calling 60% of the time. That doesn't meet the mark of an outside salesman. When are wages due? It really varies slightly when they're still employed, separated from employment, and can also be adjusted based on a pre-existing company policy. So when employees are still employed, wages are due within 10 business days of the end of a pay period, okay? Regardless. So the one caveat there is if an employee does not submit their time card by the date required, that can extend to the next scheduled payday. Separated from employment. So the way that that's indicated in statute and rule is that wages are due immediately within 4 hours or the end of the business day, unless there's this pre-existing company policy, which can extend the date of payment to that next scheduled payday, not to exceed 15 calendar days. A good rule of thumb is 2 weeks. I'm really not sure why in one portion of statute it addresses 10 business days and another portion it addresses 15 calendar days. Seems to me there might be handy to have a continuity of dates there, but I guess we're only one off, and it is what it is as far as the statute goes. Withholdings. So damages, mistakes, shortages, those aren't permissible to withhold wages from an employee. You know, the one that always pops to my head is if individual is a server and they drop a tray full of food going to a table, that doesn't get to be withheld from their wages. If an individual is running a cash register and they have a shortage, they're not able to withhold that shortage from their wages. If a chef overcooks a ribeye, they're not able to withhold that mistake from their wages. An interesting example I had a couple of years ago was I received a call from an employer that I'd done a fair amount of work with, just adjusting some company policies, et cetera. And their HR manager reached out and said, "Hey, Logan, I'm a little concerned what the owner would like me to do. They want me to withhold the cost of our insurance deductible from one of the employees." And I said, "Well, you know, let's unpack this a little bit. What happened?" And she said, "Well, the guy was driving the company forklift and ran it into a customer's car." And I guess that is, I told her, I said, you could look at this as a coaching opportunity. You could look at it as an opportunity for education and expanding their knowledge or reviewing their abilities. But what it's not is an opportunity to withhold the cost of the employer's deductible. What can be withheld are taxes, garnishments, etc. So wage-related records, and this is kind of interesting right now in the current environment as we've had so many folks working remotely, and this will come up again in youth employment, but essentially nothing changed, right? So the what I mean by that is nothing changed on the requirements of the employer, and nothing changed once it comes to youth employment to the hours and a youth is able to work. Okay. So wage-related records that are required to be kept are hours worked, rates of pay, and any withholdings made. The way I generally express this to an employer is, imagine that you had an employee separate and they filed a wage claim with our office. What you'd want to be able to provide is documentation indicating that you've paid them properly. And statute and rule does address that. What it doesn't address is the methodology of how those records are kept, right? So, you could keep those in an Excel file. You could keep those through an outside payroll service. You could keep those utilizing QuickBooks, et cetera. Or you could write them on the back of a napkin and photocopy them and get a copy to the employee and put a copy in a manila envelope and retain it. Both are legal. One may certainly have a higher efficacy than the other, but the statute and rule does not address methodology. It simply addresses that these records are required to be kept. And wage-related records are a little different in the timeline. They're required to be kept for 3 years. A lot of folks will default, and it's not at all a bad practice, to retaining them for the same amount of time that they do tax-related records, and that's perfectly permissible, but at least a minimum of 3 years, because that's the maximum look-back period for a wage claim. I guess I jumped ahead of myself there. But yes, you clearly all know the answer now. It's 3 years with that one. So how could an individual get paid? Hourly, commission, piece rate, salary bonus, salary commission, flat rate, combination. Yes, all permissible. Much like record keeping, what we don't see is the statutes or rules indicating specific. Now, to tie this back with independent contractor, clearly when you review an employment relationship, hourly, as it has been addressed through the courts, is more indicative of an employee, where piece rate, for instance, or on a job basis might be more indicative of an independent contractor. That doesn't mean, I know of folks in manufacturing facilities that make piece rate. The biggest takeaway here is minimum wage needs to be met and all applicable overtime needs to be paid accordingly. Other than that, it ends up being a matter of discussion between the employer and the employee to determine what they what they choose to be the best, either driver of performance or best for that particular industry. There's obviously industries that, for instance, are heavily reliant on commission. For instance, I'm thinking of some specific inside sales ones that I'm aware of that, the one caveat there is that if the individual doesn't make enough in commission, if they're not an exempt employee, then they need to be paid at least minimum wage for all hours worked. And what's required paid time? So meetings, trainings, those are addressed in the administrative rules of Montana. And the biggest thing is that it essentially can't benefit the company if they're not going to pay. So if the meetings or trainings are done during company time, if the company benefits, if they're mandatory, then and any productive work, like learning something on behalf of the company, that'd be required to be a paid time. What wouldn't be required is, let's say my employer let me take an afternoon off to go to a fly fishing seminar, right? Be really neat if they paid me for it, but they won't, and they don't have to. It's not at all work related. It would be off company time, etc. Preparatory and concluding activities, things happening before and after a shift. A individual mopping a floor of a kitchen is a common one that comes up. They have to clean their workstation. The company's benefiting. The larger prism to look through is, does the employer benefit from this activity? And then the other reference in the administrative rule is suffered and permitted to work. And personally think that language might be suffered seems a little harsh, but it is a language that is utilized. So we'll run with it. So if an employee is required to do it and the company benefits, it's paid time. On-call time. So the simple act of carrying around a cell phone is not in and of itself so restrictive as to be on-call time. There was even a case years ago, and it might have made it all the way to the Supreme Court, I'm not sure, involving an individual, and I believe they were out of the Missoula area, that was required to stay within the city limits during on-call periods. That's not paid time. Didn't have to be. The courts found that it was not so restrictive to be viewed as work time. That being said, let's say an individual works a 40-hour week, Monday through Friday. On Saturday, they receive a phone call. They answer that phone. They're in overtime if they're a non-exempt employee, as well as the whole time they're answering that call. That is going to be work time. If they then have to go into the facility, clearly that's going to be work time. All minimum wage and applicable overtime laws apply at that point. One thing I've seen in the last few years, really driven by the market and in the particular dynamics of our employment market, is it's become more common for folks to offer bonuses if they are asking people to be on call. One instance I'm thinking of, there was a private employer that had a group of 5 employees or 4 employees maybe that rotated who would be on call every weekend. None of them routinely worked Saturday and Sunday, but they always needed one person on call. So what they did is to entice people and to improve, I believe as they would view it, improve morale, and to build the culture they wanted, the company opted to offer a financial kicker in the form of a bonus every month when people were willing to sign up for on-call time. That went above and beyond and certainly permissible. Sleep time, shifts under 24 hours, sleep times not permissible to leverage. An individual may be allowed to sleep, but that time can't be deducted from their time. Shifts over 24 hours, if the individual is provided adequate sleeping quarters and given an opportunity to sleep, a maximum of 8 hours may be withheld from their time. That would be that they are given 8 hours to sleep. The sort of interesting thing with that is those 8 hours, or any of those 8 hours, don't have to be consecutive. So what I have seen before is employers use 4 hours rather than a full 8 hours. And one instance I'm thinking of, the employer actually spaced each of those 4 hours apart, which does not seem conducive to restorative sleep or improved employee performance. But I believe in that at that time it was within the law. A common question that arises: are raises required? And the short answer is no. If minimum wage is being applied and all applicable overtime is being met, raises aren't required. Again, it's market driven, and it's an employer's choice, and it's an employee's choice to either continue their employment with that employer or look elsewhere. So many of these things, what you end up seeing going above and beyond, are dynamics of the market and the culture that the company is truly looking to promote. Another area of common confusion: rest breaks and meal periods. The last few years, folks coming in from some different states, it's become I would say nearly a daily question in our office that, my boss isn't giving me my mandated break or meal period. And the answer, well, there's not a mandated break or meal period. It's not addressed in federal nor state law. Again, it's up to the company's discretion. Many choose to do it. It's often viewed as customary. There's many studies out there that address the efficacy of them, but it boils down to a company decision. Travel, home to work, all in a day's work and away from the home community. So in a non-pandemic environment, I drive into the office. That's not paid time. As much as I might like it, State of Montana is not paying me to drive from my house just outside of Helena into Helena to my office, all in a day's work. But what that is we'll use a individual working for a cleaning company. Let's say that they drive into the main office to gather their list of customers for the day, as well as supplies needed to service those customers. So the drive into the office, as discussed, and home to work is not paid time. Now, every subsequent stop from the office to their first, second, third, however many stops they have along the way, that's all work time. That's all going to be viewed all in a day's work. We'll throw a little example in there. Let's say the individual is allowed a lunch break. So along the way, they stop at a restaurant or a park to eat a bag lunch or leftovers or whatever and read. If they can clock out for an hour, they're completely removed from duty. That's not paid time. They pop back on. That is paid time, and go back into all in a day's work. Use that little example to let everybody know that, and it's come up, I guess, especially during the pandemic environment of record keeping and how that is done. There are a multitude of apps out there, several of them free, one including from the U.S. Department of Labor, that are hour tracker apps. So an employer can have an employee track their hours. Now, one key is it's the responsibility of the employer to mandate that those hours are being tracked. So, they might need key performance indicators or follow-up evaluations, et cetera, to make sure that metrics are being met. And some of those are as simple as, are you recording your hours worked? But that ends up going into a coaching opportunity or disciplinary action. But, I'd strongly encourage, if people are having any issues, the phone apps, specifically the one from the US DOL, I've heard from employers that they've worked well for them as they have remote employees away from the home community. So we'll use the example. If I was traveling up to your neck of the woods today, when I drove into the office, it wouldn't have been paid. As I gathered my supplies, my computer, et cetera, got the state rig to head up that way, that would be paid time. My travel, let's say I went up the night before, so I didn't have to, drive in the dark in the morning or whatever the case might be. So I go up the night before. Once I get to the hotel room, I'm free to do what I want. I'm no longer on the clock. I can go have a sandwich. I can grab a cup of coffee, whatever the case might be. I'm removed from duty. That's not paid work time. In the morning, I jump on the computer. I start answering emails for work. That is paid work time. I drive to the college there. If this was a live event, that's going to be work time. I drive back to the office. That's work time. From the office, I turn in the state rig and I go to head home. Now we're back into home to work. One area that's been fairly confusing for some folks with this is when it comes in to occupations where there isn't an established working facility, right? So I'll use a relative of mine. He works in the trades. So based out of the Helena area, they do work in Great Falls. They do work in Helena. They do work in Belgrade. They do work in Bozeman. They'll do work, Clancy, Montana City, Townsend, et cetera, wherever people have the money to pay them currently as they're in the building trades. It's not they can sort of be selective, but the example I'm thinking of is they were routinely working in Belgrade for a summer. And though they weren't required to carpool, they weren't required to pick up materials along the way, they weren't required to ride in a company vehicle. The employer simply said, be at the job site to start at 7:45. As long as they were at the job site to start at 7:45, everything was good. The minute that employer says, nope, I mandate that we're going to ride in a company vehicle, paid time. He mandates that I mandate you guys are all going to carpool in a company vehicle, paid time. I want you guys to all jump in my rig and I'll drive so we can have a meeting on the way there, paid time. If the employer requires an individual to stop and pick up materials, paid time. So those are little intricacies. And again, feel free to call our office. I earlier this spring walked through this with a construction company that had a bunch of really good questions. One of them being they didn't require people to ride to the job, but what they did require is that they had a meeting preceding them beginning work at 8 o'clock. So they had what he referred to as a tailgate meeting from 7:45 to 8. It was mandated. It's paid time. The company benefited. The employer was required to do it. Holiday, vacation, PTO, sick time in the private sector, not required by law. Obviously, there are times where they're negotiated for in contracts, et cetera. The one caveat on here, and I guess two, one we've discussed already, that it's not applicable towards overtime. The other is that vacation and PTO are viewed separately under the law. So PTO, whether indicating paid time off or personal time off, is generally viewed as like a larger umbrella of time. And that's viewed separately from vacation. Vacation has been deemed payable as wages once it's earned. So there cannot be a use it or lose it policy on vacation. There can be currently on PTO as long as it's reflective of the company policy. So PTO 100% reflective on the company policy. Vacation cannot have a use it or lose it. So in the event that a wage claim is filed with our office, the one misnomer that we see often is that we represent one side or the other. We don't. What we do is we analyze the situation to determine A, if it's in our jurisdiction, B, if it's in the statute of limitations. If it is, then we'll undergo a thorough investigation. During the investigatory process, we don't represent either side. We're a non-biased third party. In the event that we do issue a determination indicating that wages are due, penalties can range from 15 to 110%, depending upon the nature of the penalty, as well as how soon that penalty and wages that are due are paid. And then both parties have appeal rights. So with the wage claim, an individual appeals, let's say all documentation wasn't received. An individual goes, you know what, I forgot, or an employer goes, I forgot, I found the policy, or I found the company file. Then it goes into a redetermination. Case is opened back sort of anew. All the evidence is reviewed, including the new evidence. A second finding is issued. Both parties have the opportunity to do that, as well as a traditional appeal, which goes to mandatory mediation prior to going to the Office of Administrative Hearings. So, there is a due process component to this. Youth employment. This time of year, this seems to come up a lot. The number one takeaway from this is that the Montana child labor laws predominantly mirror the federal child labor laws. The higher standard is applicable if there is a difference. So if there is a difference between state and federal statute, presuming that the company or employee would be under the FLSA, and we've discussed that prior, nearly everyone working in the state of Montana, then whichever one is more protective of the employee is going to be viewed. The feds have the best resource I have seen. So if people have questions, I'm going to provide our direct contact at the end of this. Reach out to us. Don't presume you understand. If you really are on the fence, I would really caution people not to take their buddy's word for it. I believe the maximum child labor violation through the feds is $50,000 per child per occurrence. Often that's offset with mitigating circumstances, et cetera. But reach out. And the feds have by far the best resource, and that's youthrules.gov. Employers have a section there. Employees have a section. You can drill down by age. You can drill down by occupation, et cetera. Much as we discussed with record keeping, child labor hour restrictions didn't change when children are doing remote learning, for instance, in a COVID environment. Same's true for homeschool kids. Same's true for private school kids. What they review is the public school district in which the jurisdiction would lie. So there are age restrictions, hour restrictions. We've discussed jurisdiction, hazardous occupations. So our restrictions are for 14 and 15-year-olds. Outside of that, there are no hour restrictions. So 14 and 15, they can't work more than 3 hours a day on a school day, including Fridays, unless the school district in which they're located aren't open Fridays. Not more than 18 hours in a school week, not more than 8 hours on a non-school day, and not more than 40 hours in a non-school week. Non-school weeks could be summer break, spring break, um, winter break, etc. And, I guess the one thing would be the feds outline the specific timeline for the 7. So rather, initially it's 7 a.m. to 7 p.m. The feds outline, and it is over the summer when it goes until 9 p.m. Again, those are the only hour restrictions that exist. I had somebody in Billings a couple of years ago ask me, does that mean that their 17-year-old can work till 2 a.m? And I said, well, legally, yes. However, as the father of 2 children, I can assure you that my children won't be working there if I deem that that's not appropriate. Because I'm their dad, and I'm going to deem as I see fit, regardless of the minimum standards of the law. So hazardous occupations, and this is where youth rules will really come in handy. They essentially tier up as the child gets older. So 14 and 15 are going to have the most most hazardous restrictions, and then they sort of filter off until you get to 18. Registered apprenticeship. So businesses can apply with the department to become a registered apprentice or a member of the registered apprenticeship program. Then they can employ 16-year-olds and older who also become registered. An example of this is I know somebody who works for the state that their company also owns a meat processing facility. So their 16-year-old son, they got registered. He became their registered apprentice. He was then able to work doing a job otherwise deemed as hazardous at 16 years old. And he got to work right next to his dad and granddad. So not only was it a great way for him to learn skills, a lot of companies are utilizing this to onboard people so that they're not retraining people at a later date. They're really getting people in with their culture, et cetera. But before you run into the presumption that something you read on Google or something your buddy said or something you heard maybe from another business owner, before you run with that, reach out to us. Pop on youthrules.gov. We'll gladly get everything sorted out and make sure you're going in the right direction. Prevailing wage. What is it? Does it affect me in jurisdiction? So jurisdiction, real quick, there's federal prevailing wage, the Davis-Bacon Act, and state prevailing wage, or the Little Davis-Bacon Act. Both of them address public works projects over $25,000. If it's funded by the state or a subsection thereof, state jurisdiction, the feds or a subsection thereof, federal jurisdiction. If you're employing people on a public works project that the project is over $25K, then yeah, it probably affects you. And what is it? It's a minimum wage, essentially. So rate schedules are posted that are going to lay out an hourly rate and potential fringe benefits and any travel that may arise. They're on our website. They're updated annually. They're updated via method of a survey. So there's several different fields. So construction, non-construction, heavy, highway, et cetera. And then there's regions of the state, and then there's occupations. So it's basically drilling down, finding what the rate is, and then paying by that rate schedule and maintaining accurate records. So the state doesn't require you currently to submit the records. It's just that you retain them as with all other records. The feds do have a form that you are welcome to utilize for the state or the feds. Simply Google federal prevailing wage. It's a nice Excel sheet that's really all set up and ready to go for you. We have a statistician in-house. He conducts annual surveys of all folks that have done prevailing wage projects in the preceding years or in the prior years. We establish those rates. We inspect and audit payroll records due to either investigations, things that have turned up, complaints, et cetera. Wage claims still apply. We'll conduct on-site visits. and we'll do like we're doing today and educate. Sometimes we'll have specific questions addressing that. And again, reach out to our office. That's the big thing. We're a resource. That's what we're here for. I monitor this email address right here, this DLIERD@mt.gov, as well as the other managers in our bureau. And we have a call center that is staffed by investigators and auditors, 8 a.m. to 5 p.m. Monday through Friday. Call, talk to us. If we don't know, or if it's outside of our jurisdiction, we'll do some digging. And with that, I'd like to open it up. Does anybody, I know we've been drinking from the proverbial fire hose for the last bit, but does anybody have any questions I can address today?
Wow, Logan, thank you so much. Aside from gifting your time and sharing your expertise with us on this topic today, I know that we do have some questions pouring in. We are unfortunately rather limited on our time that's left, so I think we have time to take one quick one, but I would really encourage everyone in our audience who has unanswered questions to follow up directly with Logan at his contact information that's listed, and we will also put his information again up at the end of the presentation. So one question here, Logan, is what are some of the most prevalent issues your office is currently seeing?
I'd say the largest are sort of a mixture of an uncertainty on what is an employee and what's an independent contractor. As we addressed prior, it's not as simple as somebody receiving a 1099 or a W-2. And it's not just, let's say, a hiring agent wanting to tell somebody that they're an employee. That doesn't make the mark, but the full A/B test has to be reviewed in the 4 factors, as well as people being confused that because somebody receives a salary, it means that they're an exempt employee. That's not true at all. Individuals, not exempt employees, can be paid a salary. A salary is just a method of payment. It's not anything thereof. It's a component of the exemption if they meet that 684 a week, but what it's not is definitive of in and of itself, it being an exemption.
That is very helpful. Thank you for clarifying that for us. And as much as we would love to go and review all of these other questions that have come in, we are going to have to ask the audience to follow up with you. And I should also let our audience know that we did run into a mild technical difficulty. So not everybody who reported their attendance was actually able to be recorded. If anybody would like to, they can certainly contact job service to request either a certificate of attendance or just let us know that they were here today and give any feedback they would like. Next month on May 25th, the blueprint topic will be preventing violence in the workplace, presented by Officer Dennis Bain of the Kalispell Police Department. Blueprint for Business Successes seminars will then take a 3-month summer hiatus, returning in September with our fall lineup. As a reminder, there will be an anonymous 2-minute survey that pops up when you leave today. Your participation will help us improve this program and provide meaningful topics and content. Logan, thank you again so much for sharing all that wisdom with us, and thank you to everyone who attended today.
Thank you. I hope everybody has a great day and a wonderful rest of your week.
You too. Thanks. Bye.